Hi, I'm Rod Kight, an attorney who represents businesses in the cannabis industry. On December 18th, 2025, President Trump signed an executive order entitled Increasing Medical Marijuana in Cannabidiol Research. I'm going to discuss what the executive order says and provide some commentary about it. As a starting point, I should note that the United States categorizes drugs into 5 categories called schedules based on their abuse potential, addiction risk, and accepted medical use. Schedule 5 is the least restrictive, and Schedule 1 is the most restrictive and is reserved for drugs with a high abuse potential and no accepted medical use. This is where marijuana has been scheduled and classified since the U.S. started using the scheduling classification system. In fact, there's a historical argument to be made that a significant reason that our drug classification system was created in the first place was to restrict and prohibit access to cannabis. But that's a story for another day. In 2023, the Department of Health and Human Services recommended to the Drug Enforcement Administration that marijuana be controlled under Schedule 3 of the Controlled Substances Act. Schedule 3 is for drugs that have a potential for abuse less than the drugs or other substances in Schedules 1 or 2, a currently accepted medical use and treatment in the United States, and a potential for moderate or low physical dependence or high psychological dependence in the event of drug abuse. According to the executive order, and I'm quoting here, quote, "The recommendation from Health and Human Services included a determination that medical marijuana has a currently accepted medical use. That determination was based in part on a finding by the Office of the Assistant Secretary of Health that more than 30,000 licensed healthcare practitioners across 43 U.S. jurisdictions were authorized to recommend the medical use of marijuana for more than 6 million registered patients to treat at least 15 medical conditions. It was also based on a finding by the FDA of credible scientific support to substantiate the use of marijuana in the treatment of pain, anorexia related to certain medical conditions, and nausea and vomiting induced by chemotherapy. The National Institute on Drug Abuse concurred with the FDA's recommendation that marijuana be rescheduled from Schedule 1 to Schedule 3. And in May of 2024, the Department of Justice issued a proposed rule to reschedule marijuana to Schedule 3. The proposed rule received nearly 43,000 public comments and is currently awaiting an administrative law hearing. Now, the executive order goes on to state that, quote, "The federal government must improve the research infrastructure for medical marijuana to better serve Americans." Regardless of your thoughts on Schedule 3 and or politics in general, this statement is remarkable and historic. Additionally and unexpectedly, the executive order specifically addresses hemp products. And it's worth quoting this section. Quote, "In addition to medical marijuana, which is primarily made up of 2 cannabinoids, cannabidiol, CBD, and tetrahydrocannabinol, THC, hemp-derived cannabinoid products defined in the Farm Bill of 2018 have shown potential to improve patients' symptoms for common ailments and are frequently used by Americans. In fact, 1 in 5 United States adults and nearly 15% of seniors reported using CBD in the past year, and chronic pain patients have reported improvements with CBD use in clinical studies. Furthermore, evidence suggests that the amount of THC in hemp-derived cannabinoid products can affect both pain treatment efficacy and adverse events. Hemp-derived cannabinoids, as defined in the 2018 Farm Bill, are not controlled substances under the Controlled Substances Act, but are subject to the same authorities and requirements as FDA-regulated products containing other substances. Adding complexity is the fact that some full-spectrum CBD products will once again be controlled as marijuana when the continuing resolution that was enacted in November, I'm veering off from the executive order here because it uses some technical language, but when the continuing resolution was enacted that reopened the government in November, and I've written about this before, it actually includes provisions that would kill the hemp industry when they go into effect in November of 2026. And so getting back to the executive order, it references that. It says that they will again be controlled because they contain THC levels above the per container threshold set by law. So this is also remarkable because, in other words, the administration is essentially saying that hemp products are beneficial and that Congress messed up when it enacted the anti-hemp provisions in the continuing resolution last month. As I'll discuss in a moment, this is a big deal for the hemp industry. Before I discuss hemp, let's discuss what the executive order actually does with respect to marijuana. It states that the Attorney General shall take all necessary steps to complete the rulemaking process related to rescheduling marijuana to Schedule 3 in the most expeditious manner in accordance with federal law. Now, to be clear, and I think this is a point that most people are confused on, the executive order itself did not reschedule marijuana, which remains in Schedule 1 as I'm recording this video. Rather, the executive order directs the Attorney General, currently Pam Bondi, to complete the rulemaking process in the most expeditious manner under federal law. Now, there are several processes that can be used to reschedule. Based on this executive order, it appears that the Attorney General will, quote, complete that process that was started by the Biden administration. However, it remains to be seen which form that process will take and how long it will take. The hearings could be restarted or new ones initiated, or the AG could initiate formal rulemaking procedures, or perhaps, as my colleague and friend Amber Loniger noted, it could come in the form of an interim rule. Every one of these processes has its pros and cons, and we'll just see which one the AG decides to take. But regardless, it's clear that the end result, at some point, will be that marijuana is reclassified into Schedule 3. I've already had several clients ask me just within the past few hours if that's good or bad. Well, it's both. On the one hand, it's hard to argue that movement out of Schedule 1, where cannabis, marijuana never should have been in the first place, is not a positive move. I mean, this is progress on some level, right? Additionally, it will remove unfair tax burdens on state lawful marijuana businesses. It will also aid in researching marijuana, a point that the executive order makes a top priority. Now, that being said, Schedule 3 does not legalize marijuana in any real or meaningful way. Schedule 3 is for drugs with a medium abuse potential and moderate addiction risk and includes ketamine, anabolic steroids, and Tylenol with codeine. All of these drugs require a prescription and must be dispensed by lawful pharmacies. Existing state legal medical marijuana dispensaries do not meet this requirement. They will all still be operating outside the scope of federal law, and possessing marijuana without a prescription will still be a federal crime. Now, with respect to hemp, the executive order goes into much more detail and offers new hope to the hemp industry. It states, and I'm going to quote at length here, so bear with me because I think it's important. Quote, the Assistant to the President and Deputy Chief of Staff for Legislative, Political, and Public Affairs shall work with the Congress to update the statutory definition of final hemp-derived cannabinoid products to allow Americans to benefit from access to appropriate full-spectrum CBD products while preserving the Congress's intent to restrict the sale of products that pose serious health risks. This will include consultation with appropriate executive departments and agencies and authorities to develop a regulatory framework for hemp-derived cannabinoid products, including development of guidance on an upper limit on milligrams of THC per serving, with considerations on per container limits in CBD to THC ratio requirements. The Secretary of Health and Human Services, the Commissioner of Food and Drugs, the Administrator of the Centers for Medicare and Medicaid Services, and the Director of the National Institutes of Health shall develop research methods and models utilizing real-world evidence to improve access to hemp-derived cannabinoid products in accordance with federal law and to inform standards of care, end quote. So this order directs administrative officers to work with Congress to update the definition for final hemp-derived products. Now, that's strange because there is no current definition for final hemp-derived products to even update. But you know what? I'm not going to quibble with details on that issue since the order is a strongly worded message that Congress messed up by trying to ban hemp and that needs to course correct. The order also directs that several administrative agencies develop research methods and models using real-world evidence, not moralizing or anything else, but actual real-world scientific evidence to improve access to hemp-derived cannabinoid products and to inform standards of care. That's huge, and it's the strongest endorsement of hemp products, heck, of cannabinoid products that the federal government has ever issued. Now, we don't know what the hemp industry will look like in a year or two, or what hemp products will remain widely available, but this signals that the hemp industry is not going to be put out of business next year by Congress, and that's amazing. As with most executive orders, this one is light on directives and is mostly about projecting policy goals. However, you know what? We'll take those policy goals and we'll hold the administration and Congress to them. Trump signed the 2018 Farm Bill into law, unleashing a massive national hemp industry that has normalized cannabinoid use and rapidly expanded access to cannabis throughout the country. This executive order keeps the hemp industry alive while pushing the federal government into a new era where cannabis can be more easily researched and we can move, hopefully soon, to full descheduling. I guess to wrap this up, my final take is this executive order moves the ball further down the field towards the goal of a one-plant solution. And while it's far from perfect and will certainly create difficult and problematic issues within the larger cannabis industry, including the crucial question of who gets the right to produce, manufacture, and distribute cannabis. Is it big pharma, big corporate cannabis, possibly the alcohol industry, and or small businesses? You know what? We can use this as a starting point for broad reform. Thanks for listening.